My name is Justice George Odunga. I'm a judge of the Court of Appeal. I'm also the chair of the Mediation Accreditation Committee. The Mediation Accreditation Committee is a statutory body which is established under the Civil Procedure Act. Its mandate is to accredit mediators who are for the purposes of court-annexed mediation. We receive applications for those who have trained as mediators, and then we conduct interviews, and once we are satisfied with the mediators, we give them accreditation. There's a difference between Mediation Accreditation Committee and Court-Annexed Mediation Task Force. The Court-Annexed Mediation Task Force is the one that deals with the day-to-day distribution of files to the mediators and also pays the mediators once the process is over. The process of mediation is a process whereby the parties in a dispute are assisted by a third-party neutral called a mediator to arrive at their own solutions. A mediator is not a arbitrator. A mediator is not a judge. A mediator's role is simply to assist the parties to arrive at a solution that works best for them. The advantages of mediation are that first, it takes a very short time. Matters that are referred to mediation are supposed to be settled within 60 days. If they are not settled within 60 days, then they are brought back to court for hearing in the normal manner. Again, it is cheaper in terms of cost. It's cost effective because matters that are referred to mediation, the mediators are paid by the judiciary, so that the parties do not pay any money to mediators to us in that particular process. It's also a simple way of settling disputes because the rules of evidence do not necessarily apply, whereas advocates are allowed to assist parties in the mediation. Their role is very minimal. Issues of technicalities of procedure do not arise in mediation. Again, since the settlement is arrived at by the parties themselves, it's easier for the settlement to be executed. So since it's not a settlement that is imposed by a court, for example, where you may need to involve the auctioneers. But it is after the matters is settled, the settlement agreement is brought back to court. It is registered and is adopted as a court order and may be executed where parties default. Otherwise, if parties agree and they are able to settle the matter, it's not necessary to involve auctioneers. There's another aspect of mediation that is important to talk about. That is private mediation. Matters which have not come to court, but parties have agreed to mediate them outside the court. Those matters, once they are done, there's a way in which they can be brought to court. They are registered, initially not for purposes of execution, but later on parties can decide to have them also adopted as judgments of the court, in which event they then can be executed. That basically is the role of mediation, but we must make it clear that certain information that sometimes go outside there, that the mediators are paid according to the value of subject matter is not correct. Mediators are not supposed to be paid any amount of money. Those that we referred from the court is entirely free because the mediators are paid by the judiciary.